Hi, this is Neil with the Good Law Group. Today I'm going to be talking about the process and how to win a case in federal court. So first I want to talk about the process a little bit. I'm going to kind of go through the whole process to get to federal court so people understand that you don't just start out in federal court. So what happens for most people is they apply, they get turned down, they file for reconsideration, they get turned down, they file an appeal of the reconsideration, they get a hearing, they lose at the hearing. After the hearing, then you appeal to the appeals council, and if you lose at the appeals council, then the next step is going to federal court. Once you go to federal court, you can start out at the federal district court, go to the Court of Appeals, and then actually end up in the U.S. Supreme Court. And they usually take 1 or 2 cases a year that are Social Security cases in the U.S. Supreme Court. But today we're going to talk about what makes a good case for federal court. So the first thing I think that's important when you go to federal court is you have to have good evidence. You need good documentary evidence that shows what your conditions were, what the treatment you have, and what the limitations are. It's also important that you get all the medical records submitted at the administrative level, because when you go to federal court, what they look at is just what was at the administrative level. So for example, if after you have your hearing, you have surgery on your back, and that wasn't in the records, that's not something they consider. The federal court appeal is just considering the administrative record that existed at the time of the hearing. So that's why you need all the records to be submitted then. You can't add any in federal court, typically. The next thing that's important, I think, is getting a medical source statement or multiple medical source statements. Again, this is more documentary support about what your limitations are, what your doctors think you're capable of doing or not capable of doing. And this is important because you have to realize that the Social Security doctors almost always say that you're capable of working. I mean, they say that they're independent. I don't believe that. They're being paid by them. They find almost everybody not disabled. And if you think about the number of times that a judge at the administrative level overturns what happened at the application and the reconsideration, then basically what they're doing is they're saying that those doctors were wrong. So it's at least 44% of the time right now. And then if you go to federal court and they overturn that, even the judge's decision, I think it's about 40% of the time that people win those cases in federal court. So that means that the doctors that work for Social Security really provided inaccurate information that was either relied on by the judge or some other person along the line that denied you benefits. The third thing is that you need good testimony at a hearing. Okay, so if you testify that you can work, if you answer the questions wrong, you can't win an appeal. If the judge says, well, could you do this job? And you say yes, well, that's a problem. You're not going to win in federal court. So the next thing that's important is your testimony and how it actually came in at the ALJ hearing. You don't get to add any additional testimony in federal court because you're appealing the record from the administration. So, sometimes people make mistakes at hearings, and what we try and do is we try and have them correct those mistakes at the hearing. So for example, if somebody said, well, I would try and do that job. So then we would ask them, okay, what does that mean if you would try and do that job? If you can't stand up for more than an hour at a time, how can you do a job that requires you to stand up for 6 hours? And a lot of times they say, well, I would try. And I'm like, but if you try and you fail, then what are we doing here? So the whole point is you have to sort of correct any mistakes that the client makes in testimony at the hearing. You can't correct them later. The next thing that I think is important at a Social Security hearing that is used at the federal court level is the cross-examination of the vocational expert. In my mind, about a third of the cases are lost because vocational experts give wrong testimony. So what I typically do is I have like a process that I go through when I examine a vocational expert at a Social Security hearing. So the first thing I do is I try and build on the hypothetical of the administrative law judge. What do I mean by that? Well, let's just say the administrative law judge says that you can use your hands to finger, feel, and reach 2/3 of the day, which is frequently, okay? And the vocational expert says, well, there's a job that you can do if you can frequently reach, handle, finger, and feel. Okay, so then my first hypothetical typically would be, let's just change the judge's hypothetical a little bit and say it's occasional. So now he has to give a different answer, typically, because most jobs, especially sedentary jobs, require more than occasional handling, fingering, feeling, and reaching. So that's what I mean by I build on the hypothetical. Then I go on and I ask my own hypotheticals that I've written in advance. Okay, after I do that, then I start going back because I've kind of gotten everything out that might be favorable, and I start asking them questions that sometimes make them uncomfortable, like, what qualifies you as an expert? How do we know that you have the skills necessary to answer the judge's questions properly? After I try and go through what qualifies somebody as an expert, I start asking them about the methodology they used to come up with the jobs and the job numbers. So, for example, I say, well, so what is your data source? How do we know that the information you're giving us is accurate about the job numbers? Then after I ask about the jobs and the job numbers, I ask them questions about their experience with these jobs. So these are a few of the things that we think are very important to win a federal court case. So what I've talked about is the process, okay, the evidence of both medical records and opinion evidence, and then how to correct testimony of a witness in a hearing, and then some minimal points on cross-examining a vocational expert. When this is all completed, then you have a complete record, and that's what gets appealed. That's why you cannot add stuff after you've had an administrative law judge hearing. Thanks for watching this video. If you have any further questions, feel free to reach out to us, see if we can help you. You can contact us at the contact information below. Thank you.